Good evening, ladies and gentlemen, and welcome to this annual lecture of the Centre for English Legal History. We're very lucky to have with us this evening Michael Lobban, who started off as a Cambridge student, went to Oxford as a research fellow, so you can see it's all downhill, and then has taught, I'll put them alphabetically because I can't remember the order, in Brunel, Durham and London, first at Queen Mary, and then currently at the LSE. Nobody who works on the 19th century can be remotely unfamiliar with his work. Even those of us who are dragged into it kicking and screaming spend a great deal of time with what Michael has written, and we are always a lot the better off for being able to read it. His paper today is it's a long title. Martial Law in Black and White, the Rule of Law, the British Empire and the Privy Council 1899 to 1906. And I assume he's going to be dealing with the overlap of those three rather than talking about the Rule of Law, then moving on to the British Empire, then moving on to the Privy Council. There'll be time at the end, we hope, for questions, maybe even a little bit of discussion. And then, as always at these lectures, there'll be drinks afterwards to which everybody is invited. So, Michael.
Thank you. Well, thank you very much for the invitation. It's an honour and a pleasure to be here and to give this lecture. For late 19th century constitutional lawyers, such as Albert Venn Dicey, what made the British Constitution unique and superior to those of her continental neighbours was that the rule of law was not only one of its foundational principles, but permeated the whole system at every level. At the same time, as a veteran of the campaign to prosecute Governor Eyre for his actions in brutally suppressing the Jamaica Rebellion in 1865, Dicey was also very alive to the dilemmas presented for his vision of constitutional rule by states of exception, when, as he put it, for the sake of legality itself, the rules of law must be broken. Although martial law had not been proclaimed in England during the 19th century, it had been widely used in the Empire as well as in Ireland. The question of whether the exercise of emergency powers in times of perceived crisis could be compatible with the rule of law was consequently one which exercised the minds of late Victorian jurists and commentators when policies in the wider empire were forced onto the domestic agenda. Now, as Randy Costell's study of the Eyre controversy has shown, the resort to brute force to restore white rule in Jamaica in 1865 had presented severe problems for the moral conscience of a polity in which law was seen as the essential sinew of society. In the aftermath of the Morant Bay Rebellion, attempts were made in Britain to prosecute the governor for the execution of George Gordon after he had been moved from Kingston to a martial law area and then tried and sentenced by a martial law court. For Eyre's prosecutors, British civilization rested on a rule of law, which respected the rights and liberties of all subjects. In their view, the governor's actions, under the guise of martial law, had been illegal, and if they were allowed to go unpunished, would open the way for otherwise civilized men to revert to barbarism. That's Randy Costell's phrase. By contrast, for Eyre's defenders, martial law was not simply an exercise of brute force, but was a lawful power which had to be used to preserve the integrity of the empire. For them, in the final resort, British rule rested on power, which could, in case of need, be legitimately used, even in the most brutal ways, to coerce the recalcitrant. And as Costel shows, while the rival positions were set out both in the courtroom and the press, they were not definitively settled during this controversy. The question of whether the rule of law was woven into the very DNA of the British Constitution, or whether it could be made to give way to what he calls a jurisprudence of power, therefore remained open for debate. Now, these questions were raised before the public once again at the turn of the 20th century as a result of events which led to the proclamation of martial law in various parts of South Africa. Martial law was first proclaimed in various parts of the Cape Colony and in all of Natal in October 1899, after the Boer invasion of the colonies, which initiated the Anglo-Boer War. Though serious, the crisis at first looked as if it would be short-lived. The tide of war seemed to have turned by May 1900, when the besieged town of Mafeking was relieved, and by the start of September, the two Boer republics had been annexed to the Crown. However, just as the British thought the war was won and began to withdraw martial law, a second Boer invasion began, this time of guerrilla fighters. And martial law was now reimposed, where it had been taken away, and extended, and would last until after the war had ended in 1902. And the map you see there shows various martial law areas that were proclaimed sequentially. During this episode, martial law was used to deal with the threat of white British subjects who had either joined the invasion in 1899 or who were suspected of being sympathetic to their Boer cousins. The problem was particularly acute in the Cape Colony, which had a Dutch-speaking majority among the whites and where thousands had joined the invading forces at the start of the war. Almost 4 years after the end of the war, martial law was proclaimed once again in Natal in a very different context. On this occasion, the danger to be guarded against was not that of a rebellious white civilian population joining forces with an invading enemy. Instead, martial law was used to quell a rebellion of the subject African population. These contrasting episodes raised important questions about the nature of martial law. Although it had long been settled that the Crown could not exercise martial law powers in times of peace, when it came to war or rebellion, two questions remained unanswered, even after the Jamaica controversy. The first was whether the civil courts could hold the military to account during the crisis, or whether the executive was to be permitted to take unfettered action during periods of martial law, leaving all questions of legal accountability to be considered after the crisis had passed, either through common law prosecution or through acts of indemnity. The second question concerned the nature of the indemnity which would be granted to those who had violated legal rights under martial law. It was clear enough that Parliament could indemnify any acts done in an emergency, but this raised the question whether Parliament was to make the decision over whether to indemnify officials by applying the kinds of tests which a common law court might be expected to do when deciding whether acts done to restore order had been necessary under the circumstances, or whether it would simply indemnify by legislative fiat without looking into the circumstances. Many jurists, including Dicey, expected Parliament to make a considered judgment on the conduct of the officials involved, acting as a kind of court of the nation. According to this view, Parliament should only pass an indemnity act where the actions of the authorities had been necessary and justifiable, and only to the extent that they could be justified, so that it would be compatible with a broader culture of the rule of law. However, they had to admit that indemnity acts, what Dicey called the crowning proof of sovereign power, could turn illegality to legality simply by legislative fiat, and could not be questioned by any court on the basis that they were unjustifiable. There were consequently two different approaches which could be taken to the question of what the rule of law required in emergencies. According to one approach, actions done during an emergency were to be tested according to their compatibility with common law principles and rules. They were to be tested as far as possible by sitting common law courts or ex post facto by the legislature following similar principles. For those jurists taking this view, the principles of the ordinary common law were never to be lost sight of, even in emergencies. But according to the other approach, martial law was a lawless state, in which the jurisdiction of the courts was superseded, save insofar as they were permitted to operate by the military's consent. And then that could be retrospectively validated by legislation. So what I want to do today is to explore how these rival conceptions of emergency power manifested themselves in official policy and legal debates about martial law in South Africa during these two episodes of the Boer War and the Zulu Rebellion of 1906. As we'll see, the question of which approach was the right one could not be answered by law and legal doctrine alone. Rather, how far the common law vision of the rule of law prevailed depended on how far officials were committed to the values it embodied. So we'll see that the rule of law was as much a matter of culture as it was of law. The more those subject to martial law were seen to be part of the political community, the more the authorities were willing to ensure that legal procedures would be followed. As shall be seen, the constraints which applied to official behaviour when dealing with white British subjects did not apply when the targets of martial law were subject black Africans. Nor did a substantive vision of the rule of law find its champion in the highest imperial court, the Privy Council. So we'll see that the operation and understanding of martial law varied according to context. In the Cape, which was a colony with a responsible government, the legal and political elites generally sought to apply the rule of law rather than the rule of the commander as far as possible, both because the rebels were often their constituents and relatives, and because of their awareness of the need to effect a reconciliation between the communities once the hostilities were over. So in the Boer War, martial law was not treated as a legal void, a state of siege in which the military's command held full sway, but rather as a space whose boundaries were defined by a process of careful negotiation between imperial, local and military authorities, each of which had a different perception of what the rule of law required. Furthermore, when it came to legislating for indemnity, the matter was not treated simply as a formal legislative fiat, but as the product of a process in which judgments were to be made about the conduct of those being indemnified. By contrast, in Natal in 1906, the jurisprudence of power was much more in the ascendant. In the case of this rebellion by a black population, which outnumbered the whites by a margin of 9-1, officials in Natal regarded the proclamation of martial law as, in effect, inaugurating a state of siege, which would allow the authorities to impose a rigorous discipline on a subject population. Furthermore, legislators were content ex post facto to legalise these actions by fiat. These episodes are also important since they attracted considerable attention in London, both in the Colonial Office and in the highest court of the Empire, the Privy Council. Opinion here was often divided, with some officials and judges seeking to ensure that the principles of a substantive rule of law applied, while others were more prepared to apply what Costill calls the jurisprudence of power against those seen as enemies, which from London could either be Dutch-speaking Cape burghers or Zulu-speaking Natal subjects. Those who were worried about how far martial law in the empire might undermine fidelity to the rule of law at home took a liberal view. But those who were more concerned with the maintenance of order in the empire over subject peoples, and particularly notable here was Lord Halsbury, who had been Eyre's lawyer, those people took a less liberal view. So let's start by asking, what was martial law? What was the debate all about? By the end of the 19th century, legal writers agreed that martial law was not the same thing as military law or that law which applied to soldiers. However, there were a number of different views as to what exactly it was. According to one view, in emergencies, the Crown had a prerogative power to resort to martial law, which was in effect the rule of the commander and superseded all common law. Some jurists, such as the law officers advising the Crown during the Canadian rebellions of 1838, argued that this power only came into being when the ordinary courts were unable to operate. But others took a wider view. W.F. Finlayson was the best-known champion of the wider view, arguing that the Crown had an inherent prerogative power to proclaim martial law in times of war or rebellion. The necessity for martial law, in his view, was for the executive to determine, its decision on this matter being an act of state, which was necessarily valid in law, even if it might be open to political censure. Martial law entailed for Finlayson the suspension of the common law and the application to the population of absolute arbitrary military power. And it continued in force, not simply until the actual insurrection had been suppressed, but until peace itself was restored. Now, Finlayson's view was challenged by Dicey, who argued that there was no such thing as martial law and no prerogative power in the Crown to deal with emergencies. Martial law, for him, was not a special or distinct quasi-legal regime. Rather, what was called martial law was nothing more than an application of the common law doctrine of necessity, according to which otherwise unlawful acts might justifiably be done to secure self-preservation. Now, by 1899, the consensus among lawyers was that the Diceian view was to be preferred to that of Finlayson's prerogative view. But neither of these views matched the position on martial law taken by the Colonial Office, which did regard it as a special quasi-legal regime. The Crown's official view was set out in a circular dispatch issued in the aftermath of the Jamaica Rebellion to give guidance to governors dealing with emergencies. It advised on when martial law should be proclaimed and advised on how martial law courts were to be constituted and what their relationship with ordinary courts should be. While these regulations didn't have the force of law, it was clear that the Colonial Office was seeking to flesh out a set of rules based in part on the model of military law for a situation which was neither one of lawless violence nor one of common law rule. In its view, a proclamation of martial law was significant in that it initiated a distinct legal order from that of the common law. Now, given these divergent views, the exact nature of martial law remained unclear when the Boer War broke out. And in this context of contested understandings, the parameters and operation of martial law became the object of negotiations between various civil and military parties, which included the Colonial Office, the military, the War Office, and the local civil administration. Rather than seeing martial law as a state of exception where all law was silent and an executive ruler could simply step in and defend the salus populi, or as a state where the rules of common law necessity were all that one used, these various parties regarded it as a legal order whose parameters had to be defined as they went along. Furthermore, given that martial law would be declared by the governor of a colony with responsible government, rather than by the imperial crown, there was considerable room for civilian authorities of the Cape to bargain over the nature of the martial law they were prepared to implement. Now, the most striking instance of the negotiations over the scope of martial law took place in August 1901, when the military pressed for the extension of martial law to the Cape ports, including Cape Town, which had not hitherto been proclaimed as martial law areas. The Cape ministers resisted, questioning the need for martial law in particularly the three towns on the coast where it was to be applied. Faced with these rival pressures, the governor of the colony, Healy Hutchinson, began to negotiate, asking the commander-in-chief, Lord Kitchener, to agree to use martial law powers for specified limited purposes only, and proposing to give his ministers a written undertaking that if martial law were used for any other purposes, he would repeal the proclamation on their request. In the end, an agreement was reached with the Cape Ministry, between the Cape Ministry, the High Commissioner and the military, under which there was to be no martial law court for British subjects at the Cape ports, and no British subject was to be arrested by the military without an affidavit charging him with a crime, but martial law powers could be used against non-subjects. As this arrangement showed, if in theory martial law was a state of lawlessness responding to inexorable necessity, in practice at the Cape, it was the product of a constitutional negotiation between the civil government, the imperial authorities, and the military. The hybrid nature of martial law can also be seen in the operation of a special tribunal set up under legislation in 1900, the Indemnity and Special Tribunals Act. Now, in the first phase of the war, when the Boer forces invaded on the margins of the Cape Colony, rebels had been dealt with both in ordinary civil courts, civilian courts, and martial law courts, but the number of cases was very small. Once the tide of war appeared to have turned decisively in favour of the British, which, as I say, was fairly early on, by which time the rebellion at the frontier had begun to fade, there was little appetite in official circles to have any more martial law trials because martial law was going to be withdrawn very soon, so the government thought. At the same time, the civilian authorities had no desire to put thousands of British subjects on trial for having joined the rebellion. So in this context, a plan was developed to create a special court which would try only the ringleaders and those actively engaged in assisting the enemy. The court would sit without a jury, since it was evident that it would be impossible to find juries in the Cape which were not biased either in favour of or against the accused. Broadly speaking, juries on the coast would all convict, juries inland would all acquit, and therefore they thought, well, we can't have a jury. The tribunal which was set up was given jurisdiction to try, under the words of the Act, all cases of high treason and all cases of crimes of a political character committed before or within 6 months of the passing of this Act. So it had a time period. The Act also created a procedure under which rank-and-file rebels, so-called Class 2 rebels, would be disfranchised, that would be their punishment, but allowed to return home. This court commenced its work in December 1900 and by the end of the war had convicted over 360 rebels. But matters were complicated by the second invasion of the Cape, which occurred in December 1900, a couple of months after the passing of the Act. And this was followed, as I've already mentioned, by the reimposition and extension of martial law. The renewed outbreak raised the question of what was to be done with those who joined the second rebellion. Who was to have jurisdiction over them? Looking at the timetable set by the statute, the Cape Ministry argued that all cases of treason committed before the 12th of April 1901 should be heard by the special tribunal, while the military just said they had the right to try anybody they'd caught, whether they'd offended before that particular date or not. But as a result of negotiations with the military, a tripartite system was instituted and agreed. Those who'd rebelled before the 12th of April, whether in the first invasion or the second, would continue to be tried by the special tribunal. Those who had committed what was called an aggravated form of treason in martial law areas after the 12th of April were to be tried by martial law courts, while those who fell into neither category would be sent to ordinary civilian courts. A political compromise thus generated a hybrid system of martial law where the court before which a rebel was tried was largely defined by the date of his offence. Instead of this martial law regime being one of sheer lawlessness or executive will, it was, again, the product of a negotiation which had to satisfy the constitutional expectations of the government's ministers. Now, it didn't take long for the question to be raised as to the power of the civilian courts to review actions taken by the military. For early on, a number of rebels who'd been taken to Cape Town from the war areas began to seek writs of habeas corpus to secure their release. The early signs were that the court would uphold a view of martial law which was favourable to the executive. For the acting Chief Justice, Buchanan, held in May 1900 that the governor's proclamation of martial law was prima facie evidence of necessity, and that in the existing state of war and consequent necessity for martial law, this is a quotation, the proclamation must be taken to interrupt and suspend the function of the civil courts in these proclaimed districts, unquote. Buchanan's was not, however, the only view of the matter in the Cape Supreme Court. In the same case as the dictum I've just given, Justice Solomon endorsed the Dycean position that both the justification for proclaiming martial law and the exercise of authority under it were limited by the necessity of the situation, the determination of which could not be reserved to the military commander. To alarm London even more, in June of 1900, in a different habeas corpus case arising from martial law, the Natal Supreme Court also said that it had the power to review actions taken under martial law. Officials in London, alarmed by these decisions, referred the matter to the law officers, who confirmed that a proclamation of martial law could not prevent courts from hearing habeas corpus applications. The exercise of their jurisdiction, according to the law officers, could only be, quote, prevented by force as by a suspension of the tribunals, closing the courts. The question came before the courts again during the second phase. So in these first phase cases went away when there was a relaxation of the policy, but the second phase saw more arrests. And particularly in the second phase, a number of respectable citizens residing in peaceful areas were detained, not simply people caught fighting. And these people began to bring writs of habeas corpus to challenge their detention. The military policy of preventative detention was one which deeply troubled the Cape government and which led to the Attorney General, Sir James Rose Innes, getting into a heated conflict with General Arthur Wynne, whom he reminded that it was, quote, one of the essentials of the most ordinary justice that a man should know on what grounds he is being detained. Innes was particularly concerned by the case of one D.F. Moreira, which soon found its way to the Cape Supreme Court. Moreira had been arrested in Paarl, not very far from Cape Town, on the 15th of August 1901, and was then moved 250 miles further inland to Beaufort West. Although he was given no reasons for his detention, he was held on suspicion of contravening martial law regulations, in particular inciting people to take up arms against the king. When an application was made on his behalf to the Cape Supreme Court on the 2nd of September, Buchanan, the acting Chief Justice, again reiterated his view that the court would not intervene in martial law cases. However, he did order a return to be made to establish whether Moreira was being held in the custody of a civilian prison, over which the court did have jurisdiction, or a military one, over which he thought it did not. When the case returned to court, Buchanan accepted the Attorney General's assurance that he was being held in military custody. But at the same time, he took a position on martial law which had moved significantly from his earlier pronouncements, for he now seemed to suggest that the court might have the power to examine the necessity of martial law. As he saw it, the applicant had neither challenged the continuing need for martial law in Beaufort West, where he'd been taken, where there was martial law, nor had he raised the issue of its necessity at Paarl, where he had been arrested. And in Buchanan's view, the court just couldn't release him because he hadn't challenged it in the right way. He hadn't raised the very question of the necessity of its existence when he was arrested. Moreira's lawyers took the case to the Privy Council in November 1901, where they raised this very question of necessity which had been left hanging previously. At the hearing, Richard Haldane for Moreira argued that his removal from Paarl had been unlawful since the courts were open in that town and there was no necessity for martial law in that area. This contention, based on a test long recounted in the literature, was rejected by the majority of what was clearly a divided court. Speaking for the majority, Lord Halsbury held that, quote, where actual war is raging, acts done by the military authorities are not justiciable by the ordinary tribunals, unquote. The fact that civilian courts remained open for some purposes did not establish that there was not a state of war. Whereas the Cape Court had left some space for its own determinations of whether martial law was necessary, Halsbury's judgment in Moreira was informed by the fact that martial law had been proclaimed in the area and by the fact of which he said the court could take judicial notice that the empire was at war with the Boer republics. Halsbury later told the House of Lords, and I quote, the real English of the matter is that if you are at war, there is and there can be no constitutional liberty at all, unquote. The logic of the Privy Council's decision was that once a declaration of war had been made, something which lay within the prerogative powers of the Crown, then the courts could not question the acts of the military, for the declaration of war settled the question of necessity. In taking this position, the Privy Council in London took a view of the law which was very favourable to the executive, in effect seeking to diminish the power of the court to intervene in times of war. However, judges at the Cape still felt that they had room to check executive actions, at least where it was not completely clear that the applicant was being held in military custody. In the case of Baillie van Reenen, Sir Henry de Villiers, the Chief Justice of the Cape, who was then back in the Cape, having been away during the cases that I've discussed so far, de Villiers quashed a conviction that had purportedly been made under martial law, since the official exercising those powers had recorded his judgment on a document issued in the name of the resident magistrate, a civilian officer. That was later overturned again by the Privy Council, but what most alarmed authorities in England at the time about de Villiers' stance was his comment in the case, made in July 1902, which was after the Peace of Vereniging, which ended the war, had been signed, but before martial law had been removed. In that context, where the peace had been signed, de Villiers said, and I quote, "It cannot be assumed that martial law will be maintained any longer in view of the Privy Council's decision in Morea that martial law can only be justified by the existence of actual hostilities," unquote. This was a significant observation from the Chief Justice of the Cape, who had been one of the Privy Council judges in Morea. It seemed to suggest that since martial law depended on the state of fact that war was raging, then any immunity the military enjoyed during the state of war would simply evaporate with the peace, and they could be held accountable for their actions in court. This was not a view shared by the Colonial Office or the War Office, for whom the necessity of martial law did not depend on the fact of active hostilities on the ground or even on the formal state of war. They thought that until the country was fully pacified, you needed to keep martial law in place. And there you've got a picture of Halsbury and de Villiers. So the Peace of Vereniging, therefore, presented the authorities with a serious dilemma, given the danger that many detainees and martial law prisoners would seek the intervention of the Cape Court before the Cape Parliament had managed to pass an Indemnity Act. In these circumstances, the authorities decided that it was essential to keep martial law in place until such legislation had been obtained, and to hope that the court and its Chief Justice would stay their hands. In the event, there was no clash with the Cape Court, and that was largely for political reasons. With the end of the war, the Loyalist Progressive Party, spurred on by the High Commissioner, Lord Milner, and also by Cecil Rhodes, the party petitioned for the suspension of the Cape Constitution to prevent the holding of an election which might lead to the return of a parliament in which the pro-Boer Afrikaner Bond Party might obtain a majority. De Villiers, who was one of those who opposed the suspension of the Constitution, was well aware that if the court clashed with the executive over martial law, this would force Whitehall's hand over the suspension. So by the middle of 1902, the Cape government was quite confident that if any habeas corpus application came before de Villiers, he would simply kick it into the long grass by granting a rule nice at a long enough date to allow an Indemnity Act to be passed. But there remained the problem of passing an Indemnity Act in the Cape legislature, since many of its members were sympathetic to the Boer cause. One of the main issues to be dealt with in the indemnity legislation was what was to be done with those convicted by martial law courts. If in practice the courts had largely followed the procedure of military courts, under the well-established theory which distinguished between military and martial law, they were simply committees putting into execution the discretionary powers assumed by the commander and had nothing of law about them. Their powers, such as they were, simply evaporated with the end of martial law, and all prisoners would have to be released or tried in civilian courts as traitors. Now, the Colonial Office and the Cape Ministry were clearly very keen to avoid either of these eventualities by validating the convictions of those who'd been tried by martial law courts. But they needed to validate them in a way which would be seen to have legitimacy among the politicians of the Cape. Joseph Chamberlain, the Secretary of State for the colonies, came up with the solution of announcing a commission to examine all unexpired sentences and to report on them to the parliaments of the Cape and also to Natal, because some cases had arisen from Natal, before they passed an Indemnity Act. So the Indemnity Act would pass after they were sure that the sentences were just. So a Royal Commission was duly appointed in London, consisting of 2 English judges led by Lord Orveston, the Chief Justice, and Justice Bigham, and also consisting of Sir John Ardagh, formerly Director of Military Intelligence. The Commission looked at 794 cases in all, and in fact released over 100 before the Indemnity Act was passed. So the passing of the Indemnity Act was this political compromise where all the sentences were reviewed, and the Act itself, in fact, only passed the Parliament when there had been a promise that there would be a commission to investigate martial law after the end of the war, or rather the complete settlement of the peace. The example of martial law in the Cape Colony then shows that there were a number of divergent understandings about the legal nature of martial law which were contested both during the war and after. From the point of view of many in the military, once martial law had been proclaimed, a jurisprudence of power had to replace the rule of law, with the military having to be able to do all that was necessary for the salus populi. In some ways, the Privy Council's decision in Morea seemed to show that the imperial constitution could authorise a state of siege, giving the military, in effect, the powers of a Schmittian sovereign dictator, at least during the time of war. The case seemed to suggest that a simple declaration of war by the executive could oust the jurisdiction of the courts, and a simple fiat in the form of an Indemnity Act could oust the jurisdiction of the war's end. Taking such a formal view of legality, it was perfectly possible to make effective provision for a state of siege. But in practice, this did not apply in the Cape during the war because of the constitutional expectations of the civilian authorities who strove to act in a way which would set political limits to their power. So there was a political or constitutional culture which shaped what could be done by martial law during the Boer War. But as we'll now see, this constitutional culture was apt to disappear when the main subjects of martial law were not perceived to be part of the community whose constitutional culture was to be preserved. When the targets of martial law were not the White Cape rebels, but black Natalian rebels, we see a different view of martial law coming into operation. So let's move on to the Zulu Rebellion of 1906. On the 9th of February 1906, martial law was declared once again in Natal. It had been there during the Boer War, but this time in response to Zulu unrest. On the day before martial law was proclaimed, 2 white policemen were murdered near Richmond in the Natal Midlands. They had come to arrest 27 African men who had earlier defied a magistrate collecting the recently imposed and highly unpopular poll tax. During the ensuing melee, one of the policemen fired a shot into the crowd in the gloom of the early evening and injured one of the Africans. And this prompted an attack in which both policemen were stabbed to death. It was the first act in what came to be known as Bambatha's Rebellion, though the armed resistance led by the Zondi chief of that name did not itself break out until the beginning of April. The rebellion itself, Bambatha's armed rebellion, was quelled by the end of July of 1906, and troops were demobilized. They may have been demoralized as well. They were certainly demobilized. But martial law remained in place until the beginning of October. So you have a period of time of tension, and then in the middle you have a period of time where there's actual rebellion, but martial law extends for the larger period. Now, although the authorities in Natal initially resolved to follow the Colonial Office guidelines of 1867, including the provision that acts committed before the proclamation should not be tried in martial law courts, it was soon evident that they weren't going to follow that in practice. Within a week of the murder, 2 men were tried for it and executed by a drumhead court-martial. I think this is a contemporary painting of that particular execution. Considering the protests over the poll tax to be simply a pretext for general resistance, the local government took the view that a wider rebellion could only be nipped in the bud if firm action were taken at once. As the governor, Sir Henry McCallum, put it, quote, "Unless an example is made of those who have broken out in rebellion, the movement will be sure to spread," unquote. So in the weeks before Bambatha took up arms, martial law powers were used to discipline those chiefs who refused to pay the poll tax or who had in some way or other defied the magistracy. Instead of using martial law powers as a last resort to quell rebellion, their powers were used in a highly strategic way for political purposes. Those who were involved in the murder of the Richmond policeman continued to come before these tribunals. The authorities continued to worry about bringing them to book, as it were. And in the middle of March, 20 more men accused of taking part in the murder of the two policemen were tried in a martial law court. They were tried over 5 days on charges of public violence, murder, and being in arms against the government. This time it wasn't a drumhead court, it was a court which followed military court procedures. 12 of the defendants out of the 20 who had been identified by witnesses as participating in the crowd which killed the policeman were convicted and sentenced to death. But the fact that they'd been tried by a martial law court soon proved controversial, given the apparently peaceful state of the colony. And even before the trial, Governor McCallum had told his ministers that the murder charge should be tried in a civilian court. Nevertheless, the Prime Minister of Natal, Charles Smythe, retorted by saying, I quote, "The state of disaffection among the natives of this colony is by no means at an end, and any interference with the court-martial now sitting would have a disastrous effect on them." So it was very much the effect on the natives of not using the martial law procedure. The death sentences immediately attracted attention at the Colonial Office in London, which sent a telegram to Natal asking the governor to suspend the executions until more information had been provided about them. London's justification for this interference in Natal's affairs was that His Majesty's government would be asked to assent, whether directly or indirectly, to any indemnity act. But this telegram caused a constitutional crisis in Natal, where it was seen as undue interference by the imperial government in the affairs of a self-governing colony. And other self-governing colonies joined in the protest against London's interference with Natal's right to decide whether or not what it saw as the exercise of the prerogative of mercy should be used. In the end, the Colonial Office therefore backed down, meekly saying that it was only asking for information and not telling Natal what should be done. But what is curious is that officials in London were themselves divided over the legality of the martial law trial of the Richmond murderers. When in the midst of the crisis, McCallum informed London that Colonel Duncan Mackenzie's troops had been demobilised and that the recalcitrant chiefs had paid their fines, the Colonial Office official Arthur Berriedale Keith noted that this conclusively proved that Natal was not in a position to execute under martial law, and he expressed surprise in a minute that no one had applied to the Supreme Court of Natal to challenge the executions on the ground of the judgment in Moray that it needed a state of war. He said, well, Moray says it needs a state of war, and there plainly isn't one there. But his colleague Bertram Cox disagreed, arguing that no court had jurisdiction to review martial law court judgments. Cox said, the question whether or not the circumstances of the case justify the continuance of martial law is one of policy, primarily for the consideration of the governor and his ministers, not for a court. And in fact, it was at that very moment that a legal challenge was mounted before the Privy Council on behalf of the prisoners by Alfred Mangena, an African law student at Lincoln's Inn. Mangena sought special leave to appeal from the judgment of the martial law court, which he regarded as illegal. The case was heard on the 2nd of April, the very day that the men were due to be executed, and their barrister, E.G. Jellicoe, argued, as Keith suggested he should, that there was no state of war to justify the use of martial law. And in fact, drawing on the comments of McCallum, which by then had been published in an African Blue Book, therefore in wide circulation, he said they should have been tried in civilian courts. He also stressed that the events had taken place before the proclamation of martial law, so according to the guidelines of the Colonial Office, they should be tried in civilian courts. The application failed. Giving the one-paragraph judgment of the Privy Council, Lord Halsbury ruled that this was not an appeal from a court, but, quote, in substance an appeal from an act of the executive, unquote. He noted both that the government of Natal had felt it necessary to proclaim martial law and that the colonial courts had not been applied to. They'd gone straight to the Privy Council. The Judicial Committee did not consider whether the state of affairs in Natal justified martial law or whether the men had been properly tried. Indeed, Halsbury seemed to close the door left open in Moray to judge whether there had been a state of war or rebellion. For as Halsbury put it, quote, apart from questions as to jurisdiction, any interposition of a judicial character directed with the most imperfect knowledge both of the danger that has threatened Natal and of the facts which came before the Tribunal of War, this would be inconsistent with their lordships' duties, unquote. Despite the gravity of the issues at stake, the Privy Council did not order any stay of proceedings to allow a challenge in Natal or to obtain further information, and at noon on the very same day, the men were executed. At the Colonial Office, it was perceived that what Winston Churchill called the harsh and objectionable system of martial law was kept in being for the sole reason that Natal's Parliament could not pass an Indemnity Act until May, when it next met, and because nobody wanted to run the risk of the governor being prosecuted for murder in the interval before an act was passed. But in any event, the question of whether to take away martial law was rendered moot when, at the start of April, Bambata took to the fields, to the forests of Nkandla, and the full rebellion broke out. Where the earlier phase of martial law had seen only protests, this phase saw pitched battles with high casualty lists. But it didn't take long to suppress the revolt. On the 10th of June, Mackenzie's troops routed Bambata at Mome Gorge and decapitated him. And Bambata's followers were largely cowed. There was a further flare-up under the leadership of two other leaders, Meseni and Ndlovu, but they had also, by the end of July, been captured and defeated. By the end of July, the troops are sent home in a large parade in Pietermaritzburg. But the crushing of the rebellion did not mean the end of martial law trials. Between June and August, a number of rebels were tried, including these two gentlemen, Ndlovu and Meseni. And although McCallum again felt that they could be tried by civilian courts, the military and the Natal ministers remained keen to exhibit the show of force and use the martial law courts, not the civilian ones. He was told by the government of Natal, and I quote, "Natives cannot understand the necessity for, or wisdom of, resorting to what they consider the tedious and protracted procedure of civil courts in cases of this nature." It's really for the benefit of the natives that you need to have summary courts rather than ones using juries. It was at this point that what would become the most controversial trial under martial law took place. And this was the trial of Tilonco, whose followers had defied attempts to collect the poll tax and who had been seen brandishing spears in the days immediately after the Richmond killings of the policemen. The picture here gives you the kind of protests that were going on before Bambata's rebellion. People dressed for war, but protesting rather than fighting. Tilonco had not taken any part in the second phase of the rebellion, initiated by Bambata, and he was not regarded by the authorities as a dangerous rebel who couldn't be left at large, though he was suspected of having planned the rebellion. Indeed, pending his martial law trial, he was allowed to return to his tribe and was trusted to turn up at the martial law court, which began its hearings on the 30th of July, behind closed doors. At the trial, several African witnesses gave evidence that they had been told to arm, but only to protect Tilonco, who they feared was going to be arrested. No direct evidence was provided by any witness in the courtroom that Tilonco himself had given the order to arm. The only evidence directly incriminating him came in a statement made to the police by one witness, Santsubu, but when Santsubu was called as a witness at the trial, he denied making the allegations in the statement and said it had been typed up for him and he'd been told to sign it, or he'd be tied up to a post in the baking sun until he did. Well, Tilonco's lawyer, faced with this, the lawyer Eugene Renaud, argued that since Santsubu was discredited out of his own mouth, his statement had no evidentiary value. Nevertheless, the statement proved a crucial factor in Tilonco's conviction, particularly after the court allowed evidence of policemen saying, no, he said it all, he signed freely. And Tilonco was therefore convicted and sentenced on the 17th of August to 10 years imprisonment by the martial law court with hard labour. So, this was a conviction for activity before the outbreak of the rebellion, with the sentence after the end of Bambatha's rebellion obtained on discredited evidence. Now, if great political care had been taken at the Cape at the end of the Boer War to ensure that sentences imposed under martial law on white rebels had been just and proportionate, the same can't be said of Natal's approach when dealing with the martial law of 1906. Because Natal's parliament passed its Indemnity Act before many of the trials had even begun, requesting the governor to withhold his assent to the measure until the trials had ended and martial law could be lifted. When it came to passing an Indemnity Act which confirmed the sentences imposed by martial law courts, the Natal legislature did not feel it was necessary to make a careful judgment about the justifiability of the actions taken and the sentences imposed on those tried by martial law courts. Instead, it treated martial law like a state of siege, initiated by the proclamation, ended by the Indemnity Act. And as we'll see, this was something that the Privy Council was prepared to endorse. The Indemnity Bill, which came before Natal's Parliament in June 1906, contained no provision for the revision of sentences, as had been done in the Cape. But it was also radically innovative in one respect. Section 9 of the bill, which I've put up here, was prospective, giving the governor power to punish any rebel by court-martial, including by death, during the continuance of the rebellion, for however long the rebellion lasted. This removed any idea that the legislature had weighed up the necessity or proportionality of any actions taken or sentences imposed. Opponents of the measure in the Natal Assembly spoke of it as giving the government a blank cheque. London was also unimpressed and sent a protest to Natal. But once again, when London was faced with colonial resistance, it backed down. To avoid any clash, the Colonial Office conceded, though asked the government to end martial law at an early date. So the bill was therefore passed unamended, but the governor delayed assenting to the measure until martial law was withdrawn on the 1st of October. So the act passes through both houses, but is only assented to when martial law is lifted. In passing this blunt Indemnity Act, Natal's legislature followed a formal view of the rule of law, reluctantly agreed to for imperial reasons by the Colonial Office. Under this view, the lawless acts of the military under martial law could be rendered lawful by this simple legislative fiat. This was something, though, which concerned people in England as well as in Natal, when again actions were brought to challenge the martial law powers rather in the same way that had been done during the Boer War. And the case which was pursued with particular vigour was again that of Tilonco, whose trial, as I've said, had begun after the act had gone through the legislature. So a petition was lodged at the end of August in the Supreme Court of Natal for Telonco's release. During the argument, two different views of the nature of martial law were put forward. On the one hand, Telonco's lawyer insisted that the court had the right to satisfy itself whether a state of war existed, and therefore whether he had been legally confined. Against this, Natal's Attorney General said the court had no jurisdiction while martial law was in force and that the proclamation was conclusive. In the event, it was a divided court, but the majority said that there had to be at least some evidence brought of the need for martial law. So they told the Attorney General he had to come back with some evidence. But the Attorney General then said that the Indemnity Act had been passed, and Telonco's lawyer withdrew his application, taking the view that Telonco's sentence had in fact been confirmed by the legislature. But in fact, as London's officials perceived, this was incorrect, given that the governor had not yet assented to the measure. The act hadn't passed, and therefore Telonco could have been released, or the challenge could have proceeded. Interestingly, London knows about this but keeps stum because it thinks, well, we're going to lock him up in the end anyway. Having apparently failed, Telonco's supporters petitioned the Privy Council for special leave to appeal from the decision of the martial law court, arguing that Telonco had never taken up arms against the government, that Natal had not been in a state of war, that the civilian courts were open, and that the trial was therefore without jurisdiction. Given that Natal had not been in a state of war, as had been the case in the Boer War, this might have provided an opportunity for the Privy Council to clarify the meaning of Morea, with a full judgment on the status of martial law during times of rebellion. But again, the judgment was brief. Martial law was not law at all, Lord Halsbury declared, but the right to administer force against force in actual war. Any attempt to make the proceedings of martial law courts analogous to the regular proceedings of a court of justice were, as he put it, quite illusory. Although he conceded that there might in some cases be a doubt whether a state of war existed, in this case there was nothing to do since the Indemnity Act had been passed and these sentences were declared lawful by the Act. Telonco's case came to the Privy Council in November, so the Act had been assented to by that stage. The only thing for persons subject to such an Act of Parliament to do, Lord Halsbury said, is to obey. Now, because time is running short, I'm not going to go blow by blow through the next two cases that Telonco took to the Privy Council. Safe to say that both in Natal and in London, his lawyers sought to challenge the Indemnity Act by saying that it had been passed, it had been assented to by the governor at a point by which time the Assembly had been dissolved. In other words, the Assembly is dissolved at the end of August. The Act is only assented to in October, and they make the argument that all three parts of the legislature, the Crown, the Assembly, and the Council need all to be sitting at the same time in order for the Act to be valid. This argument gets nowhere. The Privy Council's decisions become briefer and briefer, more or less saying, oh no, not you again, go away. And in the end, Telonco was exiled to St. Helena, along with Ndlovu and Maseni and the other rebels. So the problem of martial law and indemnities posed perhaps the biggest challenge to Dicey's argument that the English constitution was characterised by the rule or supremacy of law. As I said at the beginning, Dicey's argument was ambiguous and might be read either in a formal way, which might lead to a thin conception of rule by law, or in a substantive way, which might lead to a thick conception of the rule of law. The nature of martial law powers could also be interpreted differently. The fact that they were interpreted differently in different contexts may tell us something about the culture of the rule of law. The formal view, according to which legal validity derives simply from sovereign authorization, provides space for a jurisprudence of power to be masked as a rule of law, While formally acts of power are given recognition by courts, defining when they should stay silent, or by legislatures, by ex post facto indemnities, in substance the space is created for the executive to act as a kind of Schmittian sovereign dictator, going outside law in a state of exception. Those tempted to defend a Schmittian position might argue that at such times, such a sovereign dictator must look to the deeper interests of the political community to defend its soul in the form of the state and to act against its enemies. In this view, a state of exception is still in some sense a juridical order whose purpose is to preserve the politico-juridical entity of the state. This is the view of those who would defend a Schmittian position. Yet such a view could hardly confer legitimacy on actions taken in an imperial context, in which an entire subject people might be perceived to be the potential Schmittian enemy. In the imperial context, as Nasser Hussain has argued, martial law could be used simply as an instrument of power, the power on which rule ultimately rested. If the formal view of the rule of law held great attractions where its targets were subject peoples who threatened to be enemies, a substantive view of the rule of law had much more traction in contexts where those subjected to martial law were part of the political nation whose existence was perceived to be under threat. As has been seen from the example of the Cape, martial law did not apply in the same way when the subject people were part of the same political nation as it did when they were not. The fact that both governments and judges at the Cape took steps to refine the powers claimed by the military under martial law and to test them by questioning their necessity or extent suggests that they had a different understanding of what the rule of law required than was the case in other colonial contexts when it came to martial law. And this may tell us something about the rule of law, that it is not something inherent in law, a concept which may be elaborated by a process of definition or deduction, but that it is part of the practice of a community, a cultural value which its members think important to maintain and apply when its members are targets of executive action. Thank you.